Okay, morning class, you're welcome to today's lecture on labor law. In our last class, we're looking at trade union immunity and we're looking at um, the immunity the law grants trade unions, when they carry out acts in contemplation or in furtherance of, the trade, in furtherance of a trade dispute. And so we looked at that both for the trade union as well as members of a trade union. Today we'll be moving on to look at industrial conflicts. And when we talk about conflicts, we're actually talking about a situation wherein workers either go on strike or the employers actually lock the employees out of work because of disagreements over terms and conditions of employment. So that's basically what we mean by that conflict situation. Now, where disputes are not properly handled, they often lead to conflict, and this conflict, as I did say, could manifest in strike actions or could also manifest in lockouts on the side of the employer. But we are more particularly interested in the manifestation of these conflicts when it has to do with the workers. Now, when we talk about a strike has been defined by Lord Denning in Tram Shipping Corporation and Greenwich Incorporated as a concerted stoppage of work by men done with a view to improve their wages or conditions of employment, or giving vent to a grievance or making a protest about something or other, or to support or supporting or sympathizing with other workmen in such endeavor. It is distinct from stoppage, which is brought about by external events such as a bomb scare or by apprehension of danger. So, what we are talking about here in respect of a strike is that we're talking about workers, actually trying coming together and in a concerted way stopping work in order to improve their wages and conditions of employment. And it could also be in order to sympathize with other workers who are also endeavoring, to improve their wages or conditions of employment. Now, there's a distinction in this Lord Denny's statement. It says that it should be distinguished from stoppage of work brought about by external events. For example, what we are having with the COVID-19 situation, where many companies or organizations, have asked their employers or employees not to come to work, because of the pandemic. So that's an instance of where work is being stopped as a result of an apprehension of danger, an apprehension of getting this infectious disease. Now, where work is being stopped maybe as a result of apprehension of danger, and that particular stoppage is not, a strike action. So for it to be a strike action, the reason for that particular strike action must be in order to change the conditions of work, the terms and conditions of work. Now, Section 48 also gives a definition. Section 48 of the Trade Dispute Act gives a definition on strikes. It says that strikes actions have to do with the cessation of work by a body of persons employed acting in combination or concerted refusal or refusal under common understanding of any number of persons employed to continue to work for an employer in consequence of a dispute, done as a means of compelling their employer or any person or body of persons employed, or to aid other workers in compelling their employer or any person or body of persons employed to accept or not to accept terms of employment and physical conditions of work. So here again is talking about refusal to work in order to compel the employer or any person employed, to accept, the terms and conditions of employment. So the whole idea of strike action revolves around terms and conditions of employment. Now, what if you break down the elements of this definition under Section 48, it says that the strike action is a cessation of work, and a cessation of work has been defined under Section 48 A of the Trade Dispute Act as a It includes deliberately working less than the usual speed or with less than usual efficiency. So here, unlike Lord Denny, where we're actually looking at a withdrawal from work, here we're or a stoppage of work. Here we are looking at also a situation. A strike will also include situations where work is actually being done, but is done at less than the usual speed or even less than the usual efficiency. So a strike does not necessarily have to do with the complete cessation of work, but also is a reduction in the efficiency or the speed in which work is actually done. Then as we did say that a strike action can actually be done, in order to support other employees who are actually making demands, in respect of their conditions of employment. So what we call a sympathetic strike. So a strike can be done for sympathetic reasons, in order to sympathize with other workers who are making demands, in order to improve their conditions of employment as well. Now, um, you for us to have a strike action, it will involve workers or employees. Now these employees need not be in a union, but they have to be a group of employees. So it therefore means that um, an individual employee cannot go on strike. There has to be a group action. A group of employees must come together with a concerted effort in order to go on a strike action. So a group is important, in order to go for a strike action. Now, there are different forms of strike, and if, as I did mention, under the definition of Section 48 of the Trade Dispute Act, you begin to have a feeler that strike action does not only include a complete cessation from work. There are different forms in which a strike action could actually take. The first one is what we call work to rule. Work to rule means that the workers actually work to the letter of their jobs, and they do not do anything extra outside the letter of the job. So what it means is that, for example, a typist could refuse to dispatch a letter. All the typist will do is to insist that she was employed as a typist, and so her job will not require her to dispatch letters in the process. So any extra, extra that work that is not in the that it's not go that does not actually go with the formal rendering of the terms of employment will actually be refused. Then number two is work stoppage. What this means is what most of us know strike actions to be, where a worker actually sits at home and does not come to work. That's one form of strike action that most of us are much more familiar with. Then number three is go slow. Under go slow, the worker does under go slow the worker does not stop work but observe a slow pace in discharge of their job, just as we saw under section 48, that they can reduce the speed of the job. So the speed of the job here is being reduced. Then you have walking. Walking here means that apart from the fact that the workers refuse to work, but this time they do not actually they don't stay at home. They come to the working place, and remain in the place of work. In order to interfere with the employer's business by seizing control of either the whole or part of the premises, of the business, in order to put pressure on the employer to concede to their request. So unlike they sit at home, here they are not working, but they now come, to work to become a nuisance. Then number five is overtime ban. You have where, for example, a worker is required, to work overtime when requested. Under this kind of strike action, a worker can refuse to work overtime. And then picketing. Picketing has to do with an action of workers who are, on strike, and what they do is they assemble in order to persuade other workers who have not joined the strike, to actually join that strike. So actually, what you have is kind of like a rally where they come together, and then they try to persuade other workers, who have not obeyed the strike order, to try and obey the order. Now, when it comes to strike, Section 42 of the Trade Dispute Act says that an employee who takes part in a strike is not entitled to any wages or remuneration. So once a person goes, once an employee goes on strike, that particular employee is not entitled to wages or remuneration. And it also goes on to say that such period does not count for the purpose of reckoning the period of continuing employment, and all rights and dependent on continuity are prejudicially affected. So, for example, the number of years, okay, for example, if you have to spend a particular period of time, in a particular establishment, to obtain maybe a promotion or something, and let's say you go on strike. Now, that period where you went on strike will not be computed among the number of days that you had put in order to fulfill the requisite time period. So that's what it means when it says that it can't be reckoned, it won't be reckoned for the period of continuing employment. Then also you find out that there are certain provisions that restrict the freedom of employees to actually go on strike. Section 18 of the Trade Dispute Act puts certain restriction on the employee's right to strike. For example, it says that where the procedure in section 4 or 6 of the act has been complied with in relation to the dispute, that I'm very certain that you must have dealt with trade disputes, and you must have dealt with the procedures under section 4 and 6, which provides for mediation, then conciliation, and so on. So section 4, where there is a dispute, parties should can appoint a mediator who will help to settle the dispute between themselves. So once an mediator is appointed, it means that the parties cannot, or the employees should not, go on strike as long as a mediator is appointed in order to settle that dispute. Then also you have a conciliator, where they cannot settle the dispute, or a mediator cannot settle the dispute. They can apply, a party can apply to the Minister of Labour, and a conciliator will be appointed in order to help to settle that dispute. So once a conciliator has been appointed, parties can no longer go on strike. Then where the matter has been referred to the industrial arbitration panel, parties cannot exercise their right to strike. Then also where there's an award where the award of the arbitration panel has become binding, parties cannot go on strike. Then also where the dispute has been referred to the National Industrial Court, parties can go on strike, and where the National Industrial Court has issued an award on that particular referral, then parties too cannot go on strike. So to a large extent, you find out that the right to go on strike under Nigerian law is largely restricted by law itself, in the sense that when an employee goes on strike, he is no longer entitled to payment of salary, he does not entitled to wages. When that dispute is referred to a dispute settlement mechanism, either through mediation, conciliation, industrial court, and the arbitration panel, or the industrial court, you'll find out that the employee cannot exercise his right to strike. Now, just as Oshimolo versus Federal Government of Nigeria, it was said that the court said that strike action is a breach of contract by the employee, which entitles the employer to dismiss him and all those who take part in the strike. So basically, an employee does not enjoy protection when he goes on a strike action or undertakes a strike action. The courts have held that the employer has the right to dismiss the employee that goes on strike and all those that take part in a strike action. Um, then also, if you look at Chibok versus Local Government Service Commission, the court held that a strike in any circumstance does not conform with the stipulation under, as we looked at, under Section 18 of the Trade Dispute Act, is an illegal strike. So where for example, it has been referred to mediation and uh, parties are still going on strike, that particular strike is illegal. And then Section 18, Sub 2 of the Trade Union Act criminalizes strikes done, in contravention with Section 18. So a person who goes on strike in contravention with Section 18 actually um, has committed an offense under the law. Then the other way in which this particular when strikes are actually taking place, one of the things that employees do is to picket. So when a strike is going on or there is a conflict between the employer and the employee, one of the things that the employees do is to actually picket. Now, the purpose of picketing is to persuade, as I said earlier on, persuade non-strikers to join the strike. Now, Section 43, Sub 1 of the Trade Union Act makes it lawful. So picketing is lawful. It's not something that is not recognized by the act. Unlike strike actions, picketing is allowed, under the law. We find out that the tenor of the law seems to frown at both case law and statute seems to frown at strike actions. But on the other hand, when it comes to picketing, the law actually recognizes the right of persons to picket. So in this what the Trade Union Act says that it shall be lawful for one or more persons acting on their own behalf, on behalf of a trade union or a registered federation of trade union or an individual employer or firm in contemplation or furtherance of trade dispute to attend at or near a house or place where a person resides or works or carries on business or happens to be, if they so attend merely for the purpose of peacefully obtaining or communicating information or peacefully persuading any person to work or abstain from work. So, picketing is allowed under the Act. So, parties can actually gather either at the place of work, that's trade unions or workers who are intending to either go on strike or have a grievance against their employer on the basis of the terms and conditions of employment, can actually gather around the as around the workplace or any place where workers or fellow employees could be found, in order to communicate to them information or in order to obtain information, or those who are actually gathering are gathering in order to obtain information from those who are actually addressing the crowd, and also in order to persuade persons from working. That means to abide by the strike action. But it's rather curious that the act will allow for picketing. That means allow trade unions to persuade the members, to abstain from working, and on the other hand, put so much restriction on such abstainers. It is quite curious that it's not unlawful, to try and persuade persons to work by way of picketing, but on the other hand, this going on strike itself is highly penalized under our system. Now, this picketing is only allowed where is done in contemplation and furtherance of a trade dispute. So you can't for this particular picketing to be protected under the law, or for persons who partake in a picket to be protected under the law, it must be in furtherance of a trade dispute. And when that picketing becomes violent, because what the law provides for is for peaceful communication. So if it becomes violent, then that particular, or whoever partakes in that picket, or persons who are found wanting, will not be immune under Section 44(1) of the Trade Unions Act. So someone who pickets and becomes violent, maybe participate in an act of arsoning or or assault or whatever, would not enjoy any form of immunity. Now, Now, sometimes pickets do take place in a public highway, and this is allowed. It's allowed for picketing to take place in a public highway. But such picketing, sorry, let me take you to where we are. But such picketing should not be done, in a way that prevents access to the highway. So, if, for example, the picketing is done in a way that prevents access to the highway, so that other members of the public cannot use the highway, a criminal offense would have been committed by virtue of Section 234 of the Criminal Code and 194 of the Penal Code. Then also, a person who partakes in a picket should not breach the peace. So, if you're partaking in picket, you should conduct yourself in a manner that will not be likely to breach peace. Because if you do that, you'll be convicted as an idle and disorderly person under the Criminal Code and the Penal Code as well. Now, also, picket will not have, so anybody who partakes in a picket will not have the right to stop any persons or to stop vehicles or try to persuade them not to walk, or you you know uh, using force. So you can't use force to stop people from actually walking. So all you do in a picket is actually to try and persuade verbally. So where persons commit the offense of assault, battery, or even arson, they will be held liable under the law. There is no immunity for that under picketing. With that, we come to the end of our lecture. If you have any question, I want you to send it to me by text message on my number 08169853293. Until our next class, have a good day. Thank you.